My name is Claire Bennett. I was 38 years old when my parents stood in front of 200 guests and announced that their entire $9 million estate would go to my younger sister. My father raised a champagne glass and called her the only child who had ever truly mattered. Everyone applauded. I smiled, congratulated my sister, and walked out of the ballroom. 16 months later, a probate judge looked directly at my parents across a courtroom in Charleston and asked them one question that dismantled everything they thought they had locked down forever. They had no good answer. Neither did Madison. I did. But I'm getting ahead of myself because before you understand why I was the only person in that courtroom who actually knew what was happening, you need to understand what kind of attorney I am and what I spend my days doing, and why my family never once asked. Some stories are about what happens when you fight back. This one is about what happens when you don't have to, when the people who wrote you out of the story write themselves into a corner so complete that the only way out runs directly through you. If your family has ever looked right past what you've built because they were too busy deciding you didn't matter, stay with me. Drop your first name and your city in the comments. I genuinely read them. Subscribe before we go further because this story has layers, and I don't want you missing the one that changes the whole picture. Now let me take you back to the dinner where this family started writing its own ending. I need to tell you what I do for a living before I tell you what happened at that party, because the two things are more connected than anyone in my family understood. I'm an estate planning attorney and fiduciary compliance consultant. For 15 years, I have worked with high net worth families, trustees, and probate courts to structure, protect, and when necessary, untangle complex estates. I know trust law the way a carpenter knows load-bearing walls, not because I studied it in the abstract, but because I have spent a decade and a half inside the specific, detailed, often messy reality of how estates actually work versus how families assume they work. Those two things are almost never the same. People with money tend to believe that signing documents makes their intentions permanent. What they don't understand, what most people without my background don't understand, is that estate law is full of conditions, requirements, and technical obligations that have nothing to do with what you wanted and everything to do with what you actually did. My family had no idea I knew any of this, not because I hid it, because they never asked. At every family gathering for 15 years, my father talked about his investment portfolio, my mother talked about Madison's latest accomplishment, and nobody once said, "What are you working on, Claire?" My job was background noise in a family where the foreground had been assigned to someone else before I was old enough to do anything about it. That turned out to be a significant miscalculation on their part. My parents are Thomas and Susan Bennett. Thomas is 67, retired from commercial real estate development, the kind of man who built his identity so completely around financial success that he can't distinguish between what he has earned and who he is. Susan is 64, the social architect of the family, the one who managed the story everyone told about the Bennetts and curated it carefully for 30 years. Their story had two daughters with two very different assigned roles. My sister Madison is 35, 3 years younger than me. She is genuinely charming in the way that certain people are charming, effortlessly, almost helplessly, in a way that makes rooms reorganize themselves around her without anyone deciding to. She has always been the one the family photographed, the one whose name came up first at dinners, the one my parents called the future of everything they had built. I am the one they called capable. These are not the same compliment. I figured that out around age 14 and have been living with it since. Madison's financial history stated plainly, our parents bought her first car at 17, paid her college tuition in full, covered the down payment on her condo in Charleston, and at various points over the years had quietly absorbed credit card debt, a failed boutique business, and a real estate investment that went sideways in 2021. Nobody tracked the total because tracking it would have required acknowledging that it was a pattern and not just a series of circumstances. I tracked it, not obsessively, we see, just the way I track everything relevant. My best estimate across 20 years was somewhere north of $400,000 in direct transfers, forgiven loans, and covered obligations. Mine, a full academic scholarship I applied for myself, a law degree I funded through a combination of merit aid and 18 months of miserable document review work, and a career I built from the ground up in a field my parents have never once correctly described at a dinner party. My mother has introduced me as in finance for 15 years. I have never corrected her. It stopped seeming worth it somewhere around year 3. The estate announcement party was my parents' idea of a legacy event. Thomas had been talking about retirement for 2 years. He had sold the last of his development company's active projects in the spring, the proceeds had settled, and he and Susan had spent the summer working with their advisors on what they called the family plan. The party was the reveal, the formal moment where the family and their social circle would witness the transition of the Bennett estate to the next generation. 200 guests, the Harborview Club in Charleston. Past appetizers, a dinner service, an open bar, and the kind of floral arrangements that communicate a specific level of seriousness about the occasion. My mother had been planning it for 4 months. I drove down from Columbia on a Friday evening and checked into a hotel because staying at the house had stopped feeling like an option years ago. I wore a navy dress I'd had for 3 years, comfortable shoes, and my grandmother's pearl earrings, which I wear to events that require me to be present for long periods without enjoying myself. The dinner itself was fine. I sat at a table with 2 cousins and my mother's college friend and a business associate of my father's, whose name I didn't catch. The conversation was normal family event conversation, nothing that required real attention, nothing that asked anything of me. Then the speeches started. My father stood at the front of the room with the microphone the way he stood at the front of every room he had ever been in, squarely, with the confidence of a man who believes the room is improved by his presence in it. He talked about what he and Susan had built, 30 years of real estate development, the portfolio, the legacy, the values they had tried to instill in their family. He was a decent speaker. He had done it a lot. Then he got to the point. He said that as they moved into this next chapter, they had made a decision about the future of the estate, that the $9 million Bennett estate, the properties, the investments, the business interests, everything they had spent a lifetime building, would pass in its entirety to Madison. Applause. Then Susan stood beside him and said Madison deserved it. More applause. Then my father said the line that 200 people heard, and that I have thought about every day since, not with bitterness, but with the specific clarity of someone who has been handed a piece of information they needed. He said, Claire doesn't need anything from us. He said it warmly. That was the part I keep returning to. He said it the way you'd say something obvious, a statement of fact, something everyone in the room already understood, something that required no defense because it was simply true. Claire is fine. Claire has always been fine. Claire will continue to be fine. The estate goes to Madison. My mother was smiling at Madison while he said it. Madison was smiling at the room. I was sitting at my table in my navy dress and my grandmother's pearl earrings, and I did the thing I always do when I receive significant information, which is nothing visible. I noted it. I filed it. I waited to see what came next. What came next was Thomas handing Madison a set of symbolic keys to the family home in the Low Country, the one they had bought in 1987 and had been the physical center of the Bennett family's self-image ever since. Susan gave her a jewelry box that had been in the family for 3 generations. Relatives came forward to congratulate her. I stood, walked to Madison, hugged her, told her I was happy for her, and meant exactly as much of it as I was capable of meaning. Then I picked up my bag, said goodnight to the 2 cousins at my table, and walked out. I want to be honest about what the drive back to the hotel felt like because I think people expect a different answer than the true one. It wasn't rage. It wasn't grief, exactly, though there was something in the vicinity of grief, the specific sadness of having a thing confirmed that you have suspected for a long time and have been hoping you were wrong about. What it mostly felt like was resolution. Not the satisfying kind, the mathematical kind, the kind where the equation has finally balanced and you can stop carrying the variable in your head because the answer is on the page. My parents had spent 38 years telling me in 100 different ways that I was the daughter they didn't need to worry about, the capable one, the one who'd be fine. And standing up at a party and announcing it to 200 people in front of the family's business associates was just the final, loudest version of the same thing they had always said. The irony. And I want to be careful here because irony is not the same as satisfaction, is that they were right. I didn't need anything from them. What they had failed to calculate was what that actually meant for the thing they were trying to protect. Because here's what 15 years in estate law teaches you about families like the Bennetts. The person who doesn't need anything is very rarely the problem. The problem is almost always the person who needs everything, receives everything, and has never once had to manage anything alone. Madison had never managed anything alone. And what my parents had just handed her, $9 million in trusts, properties, investment vehicles, and business ownership interests, all of it with complex legal obligations and fiduciary responsibilities and tax implications and maintenance requirements, was not a gift. It was a test she had never studied for. I sat in my hotel room that night and thought about Jonathan Pierce. Jonathan was the Bennett family's longtime estate trustee, 67 years old, meticulous, the kind of professional who takes his fiduciary duties seriously in a way that doesn't bend for family sentiment or parental preference. He had been working with my parents' estate for 12 years. He and I had met twice at family legal events and had spoken the precise, careful language of people in the same field who recognize each other's fluency. I wondered, sitting in that hotel room, how long it would take Jonathan to call me. Turned out to be 7 months. I went back to Columbia the next morning and didn't think about the Bennett estate again for a while. That's not entirely true. I thought about it the way you think about a structural problem in a building you no longer live in, with professional curiosity rather than personal investment. I had filed the night away in the same mental drawer where I keep things that are true but no longer mine to fix. I had my own practice, my own clients, a life I had built without anyone's down payment. I sent Madison a birthday gift in March, the way I always had. I called my mother on Mother's Day the way I always had. The estrangement, if you could even call it that, was quiet rather than dramatic. The absence of pursuit on my part rather than any declared rupture. I simply stopped expecting more than what I had always received, which was very little, and I let the relationship settle into whatever shape it wanted to take without my effort propping it up. What I heard about the family came secondhand, the way most family information arrives once you've stepped slightly outside the inner circle. A cousin mentioned at a wedding that Madison had bought a boat. My mother's college friend, the one I'd sat next to at the party, sent me a Christmas card that mentioned almost in passing that Madison and her husband had purchased a second home in Beaufort. I noted these things the way I note most things, filed, not acted on. Madison's life was Madison's life. But I want to be honest about something because I think it matters for understanding what happened next. I am a professional in this exact field. I knew, in the abstract, what $9 million in transferred assets looked like when it landed with someone who had never managed a balance sheet larger than a personal checking account. I had seen this pattern more times than I could count in 15 years of practice. It rarely ends well, and it almost never ends well quickly. I just didn't expect to be the one who got the call when it started to go sideways. Jonathan Pierce called me on a Tuesday afternoon in October, 7 months after the party. I recognized the number before he said his name, Charleston area code, a firm I'd had professional dealings with years earlier on an unrelated matter. He introduced himself with the careful formality of someone who has rehearsed how he's going to open a difficult conversation. He said he hoped it was all right that he was reaching out. He said this wasn't something he took lightly, given the family relationship, but that he had reached a point where his fiduciary obligations required him to seek outside counsel he trusted, and that my name had come up because, and he was careful here, because he knew my professional reputation independent of my family connection, and because the situation had reached a point where he needed someone who understood both the technical and the personal landscape. I told him to go ahead. What he described over the next 40 minutes was the kind of slow-motion structural failure that I had seen often enough in my career to recognize the shape of before he finished the first sentence. When my parents transferred the estate to Madison, the structure they used, on Jonathan's professional advice, which he'd given carefully and which my parents had partially followed and partially ignored, involves several trusts with specific distribution conditions designed to protect the assets from exactly the kind of mismanagement that protects beneficiaries from themselves. Certain funds were restricted for specific purposes. Certain assets required trustee approval before sale or transfer. Certain provisions required documented justification for withdrawals above a threshold amount. These provisions exist for a reason. They are standard practice in estates of this size precisely because the alternative, handing someone $9 million with no structural guardrails, produces exactly the outcome you'd expect from handing anyone, regardless of intelligence or character, an amount of money they have never had to manage at scale. Madison had begun treating the restricted funds as accessible. Jonathan walked me through it carefully, the way professionals talk to other professionals when the subject matter is serious and the personal stakes are complicated. Withdrawals from accounts with documented purpose restrictions, used instead for what appeared to be discretionary spending. The boat. The second home in Beaufort, which had been purchased using funds drawn from an account explicitly designated for business reinvestment in one of the inherited commercial properties. A sale of one of the protected real estate assets, a small commercial building in Mount Pleasant, executed without the trustee approval the trust documents required. I asked him directly whether my parents knew. He was quiet for a moment. Then he said that based on his conversations with Thomas, his understanding was that Thomas believed the estate was, in his words, theirs to do with as they pleased, and that when Jonathan had raised concerns about the trust provisions, Thomas's response had been that it was the family's money and nobody was going to tell them what to do with it. I asked Jonathan the question that mattered most. I asked if the transfer itself had been completed correctly, whether the legal mechanisms had actually been executed properly, or whether there were issues with the transfer that went beyond Madison's subsequent management of it. Jonathan's answer was the one that changed the shape of everything. He said there were several conditions in the original estate plan, as conditions related to tax structuring, timing requirements, and specific documentation that needed to accompany certain asset transfers. That had not been properly satisfied. He said he had flagged these issues at the time, in writing, and that Thomas had told him to proceed anyway because they were ready to move forward and didn't want to wait for what Thomas had called paperwork delays. I sat with that for a moment. Then I asked Jonathan what he wanted from me. He said he wasn't sure yet. He said he was calling because he was watching a situation deteriorate in real time, that he had fiduciary obligations he took seriously, and that he believed, and he said this carefully, professionally, without editorializing, that the family was heading toward a level of legal exposure that none of them, including Madison, understood yet. I told him I appreciated the call. I told him I needed to think about my own role here, given the family relationship, and that I would call him back within a few days. I hung up and sat at my kitchen table for a long time. I want to explain something here because I think it's useful beyond just my own story. When people set up large estate transfers, there's a temptation, understandable, very human, to think of the legal structure as a formality, something your attorney handles while you focus on the parts that feel meaningful, the announcement, the symbolism, the family legacy of it all. My father in particular has always operated this way. Paperwork was something other people did correctly so that he could focus on the bigger picture. But the legal structure isn't decoration. It's the load-bearing wall, the properly executed trust documents, the satisfied tax conditions, the trustee approval requirements. These aren't bureaucratic friction. They're the actual mechanism by which an estate either survives intact or doesn't. Skip the conditions, and you don't just risk inconvenience. You risk the transfer itself being challengeable, partially invalid, or vulnerable to exactly the kind of forensic unwinding that was now beginning to happen to the Bennett estate. My father had skipped conditions because he didn't want to wait for paperwork. My sister had then proceeded to spend against restricted funds because nobody had ever taught her, in 35 years, what a fiduciary restriction was or why it mattered. And the foundation under both of those decisions had never actually been properly poured. This is not a story about a family being cruel and getting unlucky. This is a story about a family treating legal structure as optional and discovering the hard way that it never was. I called Jonathan back 3 days later. I told him I would help, not as Claire Bennett, daughter, but in whatever professional capacity made sense given the conflict of interest, considerations he and I both understood needed to be carefully managed. I told him I wanted to review the actual trust documents and the transfer paperwork myself before forming any opinion about what should happen next. He sent everything within the hour: 12 years of trustee records, the original estate plan documents, the transfer paperwork from 16 months earlier, 7 months earlier at that point, since the announcement party had been 7 months before this call, and the recent transaction history showing Madison's withdrawals and the Mount Pleasant property sale. I spent the next several evenings going through it the way I go through any complex estate matter, which is slowly, methodically, with the assumption that the people involved made it more complicated by trying to move quickly rather than carefully. What I found confirmed what Jonathan had described and added several layers he hadn't been positioned to see fully because he hadn't had access to the broader tax documentation that I requested separately through proper channels. The transfer of the business ownership interests, one of my father's commercial development entities, had not properly accounted for a tax election that needed to be filed within a specific window after the transfer date. That window had closed. The consequence wasn't catastrophic on its own, but combined with everything else, it created a documented timeline of procedural failures that any competent forensic review would eventually surface. The Mount Pleasant property sale was the most serious issue. The trust documents were explicit. Any sale of real property held within the protected trust required written trustee approval prior to listing. Madison had not sought that approval. The sale had gone through a private buyer at a price that, when I ran the comparable market analysis, came in roughly 15% below fair market value, the kind of discount you get when you need money fast and aren't asking the right questions about what you're giving up to get it. I asked Jonathan in our next call what Madison had used the proceeds for. He said, as far as he could determine, a combination of credit card debt, an investment in a friend's business venture that had since failed, and renovations on the Beaufort property. I want to be honest about how I felt hearing that. Not vindicated, not surprised exactly, because the pattern was so consistent with everything I'd observed over 20 years that surprise would have required me to ignore everything I already knew about my sister's relationship to money. What I felt mostly was the specific, tired recognition of watching a problem unfold exactly the way you knew it would, while the people who could have prevented it told you that you weren't needed. Madison's behavior escalated faster than even I expected, and I want to walk through this carefully because the speed matters for understanding what came next. Within 3 months of the property sale, Jonathan called again. This time, the issue was different in kind, not just degree. He had requested documentation for a series of withdrawals from one of the larger trust accounts, and the documentation Madison's assistant had provided contained signatures and dates that, when Jonathan examined them against his own meeting records, didn't align with when the approvals were supposedly given. This is the part of the story where I have to be precise, because precision is the entire point. Jonathan didn't accuse anyone of forgery in that call. He's too careful for that, and he's right to be. What he said was that he had documents purporting to show his approval for transactions on dates when, according to his own calendar and correspondence records, no such approval conversation had taken place. He said he needed to understand the discrepancy before he could continue in his role with any confidence. I told him to preserve everything exactly as it was. Don't confront anyone yet. Don't alert the family. Document the discrepancy precisely, the dates, the documents, the actual record of what occurred versus what was claimed to have occurred, and then we would figure out the appropriate next step together. He asked me, near the end of that call, whether I thought this rose to the level of needing an attorney for himself, independent of his role as trustee. I told him, professionally and honestly, that I thought it probably did. I also told him, in a moment that was less professional and more personal, that I was sorry he'd gotten pulled into the middle of my family's mess. He said something I've thought about since. He said he'd been the Bennett family trustee for 12 years, and that in all that time I was the only person in the family who had ever asked him a single question about how the estate actually worked. I didn't have a response to that for a moment. Then I told him I needed to see everything, all of it. Every document, every transaction, every signature, going back to the original transfer. He sent it within the day. I spent the following weekend at my kitchen table with 12 years of trustee records spread across every available surface, doing what I do, which is finding the line that doesn't add up. It took me until Sunday evening to find the first one. It would not be the last. The first discrepancy I found was a signature. Jonathan's signature, dated the second Tuesday of June, approving a withdrawal of $240,000 from a trust account designated for property tax reserves on the Low Country house. I pulled Jonathan's calendar entries for that week, which he'd sent along with everything else. He had been in Denver that Tuesday at an industry conference. There was a hotel confirmation, a conference registration, a dinner receipt from a restaurant in downtown Denver, time-stamped the same evening the approval document claimed to have been signed in Charleston. A person cannot sign a document in person in two cities at once. I found 3 more like it over the following week. Different dates, different amounts, the same pattern. A trustee approval document properly formatted, looking entirely legitimate at a glance, dated for a day when Jonathan's own records showed he had been somewhere else entirely. I called him on a Monday morning. I asked him to look back through his email for the weeks surrounding each of these dates. Not for approvals, for anything. Any correspondence, any mention, anything that might explain how a signature appeared on a document for a conversation that never happened. He found it within an hour. An email from Madison's assistant sent to Jonathan's office asking him to review and sign a routine quarterly reserve adjustment. The email was real. Jonathan remembered receiving it. What he didn't remember, what his own calendar confirmed he couldn't have done, was the in-person meeting the formal trust document claimed had taken place to authorize a withdrawal 6 times larger than what the email described. Someone had taken a real, minor, properly authorized transaction and substituted a different document behind it. Same date, same general transaction type, completely different number. I want to be careful here because precision matters, and because I am not in the business of accusing people of things I cannot support. What I can tell you is what the document showed. What they showed was a pattern, repeated 4 times over 8 months, of trust withdrawal approvals that did not correspond to any actual meeting or conversation Jonathan Pierce could verify having had. I called Jonathan back and told him what I thought we were looking at. He was quiet for a long moment. Then he said he needed to retain his own counsel immediately, and he needed to stop signing anything related to the Bennett estate until this was sorted out. I told him that was exactly right. The investigation that followed moved the way these things actually move. Not with the speed of television, but with the grinding, document-by-document pace of forensic accounting and legal discovery. Jonathan retained an attorney. That attorney, working with a forensic accountant, began a full review of every transaction across all the trust accounts since the original transfer. I was not formally part of that engagement. The conflict of interest, given my family relationship, made that inappropriate, and I told Jonathan's attorney as much directly. What I did instead was answer questions when asked, point toward documents I had already identified, and otherwise stay in the position I had occupied my whole life in this family, present, capable, and not particularly visible until someone needed exactly what I had. The forensic review took 4 months. What it found ultimately was this. Madison had, with the knowledge and at times the active encouragement of my father, withdrawn funds from restricted accounts without proper authorization on multiple occasions. The Mount Pleasant property had been sold without trustee approval and below fair market value. At least 4 trustee approval documents had been altered or fabricated to make unauthorized withdrawals appear properly authorized. A tax election deadline tied to the original business transfer had been missed, creating additional liability exposure for the estate. The forensic accountant's report ran to 91 pages. I read all of them. The probate court got involved when Jonathan's attorney, acting on his behalf as a concerned fiduciary, filed a petition seeking judicial guidance and protective intervention. This is a standard mechanism. When a trustee believes a trust is being mismanaged or that fraud may have occurred, the trustee has both the right and the obligation to bring the matter before the court rather than simply resigning and walking away. A hearing was scheduled in Charleston County Probate Court before Judge Rebecca Lawson. I received a call from my mother 11 days before the hearing. It was the first time she had called me directly in over a year. Her voice had the brittle quality of someone trying very hard to sound calm while not feeling calm at all. She said there had been some misunderstandings with the estate. She said Madison was being treated unfairly. She said the family needed my help, that I understood this kind of thing, that surely I could explain to whoever needed explaining that this was all just paperwork confusion. I let her finish. Then I told her plainly that I had already been involved for several months, that I had seen the documents, and that what had happened was not a misunderstanding. I told her there were altered approval documents with Jonathan's signature on dates when he was provably elsewhere. I told her the Mount Pleasant sale had bypassed required trustee approval entirely. I told her this was now a matter for the court, and that nothing I could say would change what the documents already showed. She was quiet for a long moment. Then she said the thing I had been waiting 15 years to hear someone in my family say, though not in the circumstances I would have chosen. She said she didn't understand any of this, that she had never understood the trust structure or the tax requirements or any of it, and that she had simply trusted that everything was fine because Thomas had said it was fine. And now she didn't know what was fine and what wasn't, and she was asking me, finally, directly, what she should do. I told her to get her own attorney. I told her, gently, that her interests and Madison's interests and my father's interests were not necessarily the same thing at this point, and that she needed someone representing her specifically. She asked if I would represent her. I told her no. I told her I couldn't for reasons that were both ethical and personal, and that she needed someone with no history in this family at all. She thanked me anyway. It was the first time my mother had thanked me for anything related to my work in 15 years. The hearing itself was not dramatic in the way courtroom scenes are dramatic on television. It was a probate hearing. A judge, attorneys for several parties, a forensic accountant called as an expert witness, careful procedural questions, exhibits entered into the record one at a time. I was called as a witness, not for my family relationship, but in my professional capacity, to speak to the original structure of the trust documents and what the standard industry practice would have required for the transfers to have been executed properly. I testified to what the documents said, what the law required, and where the actual paper trail diverged from both. I was careful on the stand. I did not editorialize. I did not characterize anyone's motives. I answered the questions I was asked with the same precision I bring to every estate matter I have ever handled, family or otherwise. Madison was also called. I watched my sister, 35 years old, sit in the witness chair and attempt to explain withdrawals she could not adequately account for, property sales she had authorized without understanding she needed approval to authorize them, and documents she claimed she had not personally altered but could not explain who else would have had reason to. My father testified that the estate was, in his words, the family's business, and nobody outside the family had any right to dictate how it was managed. Judge Lawson, a woman in her late 50s, with the unhurried precision of someone who had presided over many estates and was not moved by tone or volume, asked him a question near the end of his testimony that I have thought about many times since. She asked him whether he understood that when he established an irrevocable trust with specific fiduciary protections, he had by definition surrendered the right to manage it however he and his daughter pleased, that the protections existed precisely because he had asked for them, on Jonathan Pierce's professional advice, and that ignoring them now did not make them disappear. It simply made the ignoring itself a legal problem. My father did not have a good answer. Neither did Madison, when asked a similar question about why she had authorized a sale of trust property without seeking the trustee approval the documents explicitly required. The court's ruling, issued 3 weeks after the hearing concluded, was not dramatic. It was precise, the way these things actually are. Madison was removed from any management authority over the trust accounts. She was ordered to repay the improperly withdrawn funds, with the court establishing a structured repayment schedule given that much of the money had already been spent. The fabricated approval documents were referred for further investigation regarding potential fraud, separate from the civil estate matter. My parents' original estate plan was found to be partially invalid due to the procedural failures in the original transfer, the missed tax election, the improperly executed conditions Jonathan had flagged at the time and been overruled on. The court appointed an independent professional trustee to manage the remaining assets going forward, removing both my parents and Madison from any further unilateral control. The $9 million did not disappear. That's worth saying clearly, because I think people expect a story like this to end in financial ruin, and that's not what happened. The estate was protected, ultimately, by the very structures my father had tried to bypass. What was lost was control. What was lost was the fiction that money could simply be declared into someone's hands without consequence for how it got there or what was done with it afterward. I want to keep the rest of this short because I think you already understand the shape of it. My parents called me regularly in the months after the ruling, not out of love rediscovered, out of need. They needed someone who understood what had just happened to their estate, what the independent trustee structure meant going forward, what their actual remaining authority looked like. I helped where I could, in a professional capacity, because preserving what remained of $9 million in family assets was the right thing to do regardless of how I'd been treated. I did not rebuild the relationship. Those are different things, and I want to be precise about that distinction because I think it matters. I helped preserve the estate. I did not pretend the ballroom never happened. Madison is, as of this telling, working through her repayment obligations and rebuilding a life considerably smaller than the one she imagined for herself at that party. The fraud investigation is ongoing. I don't know how it will resolve, and I'm not going to pretend I do. My father has not apologized. My mother has, in her own limited way, several times. 2 years out, the estate is stable. The trust is functioning properly under independent management. And I have built, entirely separate from any of this, a life and a career that never once depended on what my parents decided I deserved. My parents spent their entire lives believing money could decide which child mattered. The funny thing was, the moment they gave everything to my sister, they handed her the one thing she was least qualified to manage. And the only person who could help fix it was the daughter they'd just told 200 people didn't need anything from them. If this story landed somewhere true for you, tell me in the comments. First name? Your city. Tell me if you've ever been the one nobody worried about, and what happened when they finally needed you anyway. And if you want more nights like this one, come find us on the channel. There are stories sitting there right now that are going to surprise you in ways this one didn't even get to. Quieter ones, louder ones, a few that might hit closer to home than you're expecting. You'll know within the first minute whether it's one of those nights. Subscribe and I'll see you in the next one.